You're watching BBC News. Now, in many countries around the world, today is a bank holiday. It's an opportunity to get away from work and to relax. But what if your employers won't leave you alone? Well, if you're in Australia, you now have the right to disconnect. In most cases, employees can't be punished for refusing to return their boss's calls. Well, let's talk now to Tania Goodman, who's Head of Employment Law at the law firm Collier Bristow. Tania, welcome here to the programme. This is a fascinating development in Australia, and other places have tried it as well. It has been considered here in the UK as well. Just let's take this in stages. In terms of the merits of this, lay it out.
So this really has come about in part because during the pandemic, when we were in lockdown, a lot of people were working from home, otherwise they couldn't possibly work. And during that period, we kind of got used to a working hours culture where perhaps it was expected or we didn't have anything else to do but be switched on all the time. And certain expectations were set during that period. Coming out of all that, we've returned to normal life, thank goodness. And the workforce now wants to be able to feel that it can switch off from work and doesn't feel like it has to be 24/7 connected to the office, even though we have remote devices that make it very easier for us to do that. And the legislation is kind of catching up with that philosophy.
You can see the obvious upsides for workers wherever they are watching this. What about the downsides, resistance, opt-outs?
Well, in terms of opt-out, we already have certain legislation in place, such as the working time regulations, whereby most workers are not expected to work more than a 48-hour working week unless they specifically opt out of it. And there may be some similar opt-out provisions in relation to this right to disconnect. That remains to be seen because the legislation is not in force in this country yet, although we've seen it across Europe and today, as you say, in Australia. And, to the extent that people are doing jobs which are highly paid and they're expected to be on call, then this is not a one-size-fits-all situation. And there will be variations depending on the type of organisation you work for, the sort of contract you have, and the expectations for you to be switched on even out of contractual working hours.
Final twin thought, what are the sort of sanctions that we talk about, say, in Australia for those employers that breach this? And you mentioned it, that several countries have tried this. Has it worked?
Yes and no. I think some countries don't have very stringent sanctions applied. I think perhaps the most stringent is maybe Portugal, where there are quite heavy fines applied, but that isn't the case across the board. Sometimes it's more of a recommendation. And I think what's proposed in the UK is that ACAS, the conciliation service, would come up with a code of practice, which was sort of best practice, and companies would then consult with their workforce to make that a more bespoke sort of policy, which they could roll out across the organisation, but something which both employer and employee were signed up to and agreed to. And that way it doesn't make the legislation too heavy-handed, but it makes it more applicable to the particular industry in which you work. And I think that's more likely what we're going to see in the UK, if and when it's introduced, probably next year.
Well, it's certainly one to watch. Tania, thank you very much for coming on and talking to us here on the programme. Tania Goodman.